Alex Jones was harassed, interviewed by the January 6th Select Fake Committee, and they had a lot of questions for him about, his involvement in the end of America. They asked him a bunch of questions. Alex Jones invoked, said, I'm pleading the fifth, not going to be answering these questions, and he's getting criticized all over the place by certain congresspeople and certain media outlets who are upset about this, saying that the Fifth Amendment, it's not really for what you think it's for, and that you should be waiving this and you should just answer whatever we want from you. Doesn't work that way. Here's Jake Tapper hinting at what is happening here.
Also on our politics lead, right-wing conspiracy theorist Alex Jones is the latest person to meet with the House Select Committee investigating the deadly January 6th insurrection. Jones telling listeners on his podcast that he pleaded the Fifth Amendment almost 100 times.
Wow.
Let's get right to CNN's Paula Reed. Paula.
Okay, so 100 times is the big headline. This guy, this conspiracy theorist who's wrecking America, chose to invoke his constitutional rights, and we're upset about that. Here's how Alex Jones described it on his show.
I'm the type that tries to answer things correctly, even if I don't know all the answers. And they can then try to claim that that's perjury. Because about half the questions I didn't know the answer to, and a bunch of them were emails I'd never seen, and planning things I'd never seen, at least from memory.
All right, and so Alex Jones, of course, is also the subject of a political inquisition, one that we've covered for a long time here on this channel. And so they just kept peppering him with questions about whatever they wanted to. We've seen many of the discovery requests that have come out from Chairman Benny Thompson, just dozens of pages of documents, text messages. They want to know what you had for lunch on January 4th, 2021. And if you don't give them the details about the condiments, well, you're probably a seditionist. And so this is something that we're seeing a lot more of. The investigation is going into Sean Hannity's text messages and Sebastian Gorka. And in my opinion, it's really been a big effort to chill speech and go against their political enemies. But they're very upset now that their political enemies are invoking the constitutional protections that thankfully we still have. Here is CNN explaining.
Well, Jake Jones met virtually Monday with the committee, and he spoke about his experience on his podcast, where he described the interview as intense and said he did indeed take the fifth nearly 100 times on the advice of counsel.
Good
advice. Now, why would he do that? Well, he said the questions were reasonable, but he did not want to answer all of them for fear of perjuring himself.
Perjuring himself, incriminating himself, or getting caught in a bind because of scummy investigators like this guy. Here is Raskin. Raskin is a Democratic representative, and he's somebody who evidently doesn't really like the Fifth Amendment, wants people to bend the knee anytime one of his fake congressional committees goes after somebody. He thinks that you should just roll over and open your mouth. He's upset with Alex Jones. Here's what he said.
The thing that Mr. Jones and all of the defendants and all of the witnesses are forgetting is that the Fifth Amendment is meant to be used selectively. If you think that you might be incriminating yourself by answering a question. It's not a magic wand that you wave over the whole proceeding and you don't have to answer anything. So it's only to be used if you think that the answer that you're about to give will provide evidence to the government that could be used against you in prosecution for a crime. But if it relates to other people, if it relates to general events, if it doesn't lead to your own incrimination, you can't use it like that. So what we're seeing is this extravagant new deployment of the Fifth Amendment as a kind of, get out of a subpoena card.
Yeah, no, that's not accurate at all. So it's not an extravagant new use of the Fifth Amendment. It's pretty consistent. We're going to take a look at some of the case law that supports it. First one is Ohio versus Reiner. You can see this is a pretty new one, 2001. Comes out of a shaken baby syndrome case, and I've got some emojis to help us diagram this out for our own education and for Mr. Raskin's. It says that the respondent here tried for involuntary manslaughter. Okay, this is the respondent. This is going to be the father. He's being charged with manslaughter in the death of his son. Shaken baby syndrome, died from that cause. Defense theory was that Alex, the baby, was injured in the care of the family's babysitter, who is Susan. Susan Bott is over here. Now, this is all going around. We can see the father wants to put liability on the babysitter, saying the babysitter is responsible for the death of the child. So this investigation continues. Bott tells the court that before testifying, she is not going to talk. I'm going to invoke my right to remain silent, and I'm going to plead the fifth. refuses to testify. Prosecutors in the court come back in and they say, hey, how about this? We're going to go ahead and give you immunity, so we'll give you a shield as long as you do decide to talk. So just tell us what happened, cross the line, communicate what's on your mind, and you'll be immune from any criminal prosecution. She then testified to the jury that she had refused to testify without a grant of immunity. Okay, so she now is testifying in court, telling the jurors, I'm only talking today because I've been granted immunity. Says I've done nothing wrong. Okay, and because of this fact, because she was immune, the jurors, the defendant is alleging, thought that she was sort of precluded, that the government, the court, the prosecutor, everybody was saying that she was innocent because of that immunity. And that gave her special privilege that resulted in him being convicted. So what did he do? He appealed after he was in fact convicted, and the appeals court reversed. The state Supreme Court affirmed the reversal, and they said that Bott had no valid Fifth Amendment privilege. They said she couldn't invoke. Why? Because she said that she was innocent. Okay? Her defense was, I'm an innocent person. I'm not a guilty person. And what these other courts said, well, if you're an innocent person, you can't invoke. Only if you're guilty. And they said, therefore, that the grant of immunity that was given to her was unlawful. Court found that the grant of immunity prejudiced the father, and it told the jurors that Bott, the babysitter, did not cause the injuries. Now, is that accurate? Is that true? Does that hold? That ruling hold? No, it does not. Supreme Court comes out and said Bott, the babysitter, did in fact have a valid Fifth Amendment privilege. Okay? Court has jurisdiction. It says the Fifth Amendment privilege protection extends only to witnesses who have a reasonable cause to apprehend danger from a direct answer. Reasonable cause. Now, who gets to decide that? The court. The inquiry is for the court. The witness by themselves, asserting it alone, does not establish that risk. Okay, so just because Alex Jones or somebody says, well, I'm concerned about it, that alone is not enough. Raskin is right about this. But the court has never held, however, that the privilege is unavailable to those who claim innocence. To the contrary, the court has said that one of the basic functions is to protect innocent persons who might otherwise be ensnared by ambiguous circumstances like this. And in the Bott case, Bott had reasonable cause to apprehend dangers from her answers if questioned at trial, even though she was 100% innocent according to her. Thus, it was reasonable for her to fear that answers to possible questions might tend to incriminate her. So you're allowed to use this, and you're allowed to use it broadly. And some of the causes are, as long as it's a reasonable cause, and it applies to innocent people. Now, you'll notice that they are citing for us another case here, Hoffman versus United States. If we go to the Hoffman case, this is an older case back from 1951, and here is what this case says. And let's apply this also to some of the current situations that we're talking about. Claiming that answers might tend to incriminate him of a federal offense, petitioner refused certain questions that were asked of him by a grand jury. He'd been charged with being known as a character and a racketeer, and he refused to answer questions. The judge impaneled the grand jury. Petitioner stated that he's not going to obey the order of complying with the requests, and he was convicted of criminal contempt. So a grand jury is convened. This guy is ordered to come in and testify. He says, I am not going to obey the order, and they charge him with a crime. Now, back in 1951, this court under Tom C. Clark held that the conviction is reversed. They reversed that. They charged him with contempt for not testifying. But here, this is what this says. The privilege against self-incrimination that's guaranteed by the Fifth Amendment extends not only to answers that would in themselves support a conviction. Okay, in other words, like if you say, hey, did you punch that guy in the face? If you answer, yes, I did, that's obviously going to lead to a conviction. And so you would be justified in not answering that question. He says, yeah, that's obvious. It applies to those situations, but it also applies to those which would furnish a link in the chain of evidence needed to prosecute the claimant for a crime. A link in the chain of evidence needed to prosecute a claimant for a federal crime. And to sustain that privilege against self-incrimination, it need only be evident from the implications of the question. Implications in the setting in which it is asked that a responsive answer to that question or an explanation of why it cannot be answered might be dangerous because injurious disclosure could result. Okay, very low standard. Need only be evident from the implications of the question in the setting why it might be dangerous. In this case, the court should have considered that the chief occupation of some of the persons involved matter. Okay, what type of work they do, who they talk about, what they talk about, and things like that. Truthful answers by the petitioner to these questions might disclose that he was engaged in some type of illegal activity. And so the court is setting a very low bar. In other words, basically everybody gets to protect themselves against self-incrimination. You got to show that there's a reasonable connection between the question that is being posed and the answer that is being sought, and some sort of nexus to any type of chain of causation, a chain of evidence, is what the Hoffman case says. Alex Jones, of course, is a very prominent, prolific media commentator, somebody who has a gigantic audience and who is in and around the area on January 6th. We've seen that they're going after and prosecuting basically everybody who is even remotely connected to that day. And so it's obvious that any question that is being posed to him might have some sort of connection to some chain of evidence in one of the many tentacles of this massive national investigation that is being conducted by the Where's Waldo players over at the FBI. Alex Jones has the same Fifth Amendment privilege that you have, that I have, that we continue to hold and cherish until this government and these Democrats continue to water it down. Would love to hear what you think about Alex Jones invoking the Fifth and your thoughts about the January 6th Select Committee. Let me know down in the comments below. I'd love it if you stuck around and subscribed to the channel. We have a live show that we do daily, weekdays, and I'd love it if you joined us. I look forward to seeing you on the next one.